Welcome to our presentation on the mysteries of revocable living trusts. Let's examine what a trust is so you're not confused during your first visit with an estate planning attorney. I like to think of a revocable living trust as a basket woven by words. The words define what can be done with whatever you choose to put in the basket. So let's say you have an estate planning attorney weave one of these baskets for you. What are you going to do with it? Well, you are going to take certain assets that are now held in your name, your home for example, your investments, your savings, and put them in the basket. When you do, your home, stock, and cash are no longer held in your name. They are now in the name of your living trust dated such and such and controlled by you as trustee. What you've done is create a kind of mini-corporation that now owns some of your most valuable property. The trust document, however, puts you in control of whatever is in the basket. For example, you can do whatever you want with your home. As trustee of the trust, you will continue to make the mortgage payments and make repairs. You can sell the home, though you may be required to take the home out of the trust for the sale, but that's fine because you can take the home out of the trust any time you wish. You can tear up the trust and go back to a simple will. That's why attorneys take pains to refer to these trusts as revocable. You remain in charge. So why did you bother to go to the trouble of creating the basket? You may remember in our first session, we defined probate as a court process that makes sure that assets that are held in your name only and have no other way of passing to others are correctly transferred to others after your death. Well, if you put your home in the basket of your living trust, your home is no longer in your name. The trust names who is to get your assets at your death, and so provides another way for your home to go to those you love. If the executive of a corporation dies, the corporation does not usually go to probate court to determine what happens next. It simply looks at its bylaws and succession plan and follows them. Well, your living trust spells out in detail who is to handle the transfer of your assets of your trust and how they are to handle them. It is in effect a will substitute, but the court does not have to get involved. Anything you have transferred to the trust passes directly to those you have named without probate. The trust also avoids the problem of other probate avoidance methods, joint tenancy, for example, because my trust is revocable during my lifetime. As a result, no one named in the trust as a beneficiary has a right to the assets in the trust during my life unless the trust says they do. A joint tenant has a grip on your property during your life. The beneficiaries of your living trust do not. This brings us to another advantage of revocable living trusts. What can the executor of your will do to help you with the management of your property if you become seriously ill and cannot communicate? If all you have is a will, the executor can do nothing. He or she cannot make your mortgage payments or pay your medical or utility bills. The executor of your will can do nothing until you die. Not so the successor trustee of your living trust. The boilerplate language of your living trust empowers your successor trustee to take action and manage the assets in your living trust if you are unable to do so while you are alive. Don't worry, a properly written living trust will have language that spells out under what circumstances your successor trustee can help you. Typically, the trust will require a statement from a physician describing why it's clear you're no longer up to managing what you've put into your living trust. With that statement in hand, your successor trustee can seamlessly take over the management of the assets in your living trust until you've recovered sufficiently to take the helm again. For years, computer software has existed that individuals can purchase to allow them to personalize and print out a living trust. At an estate planning seminar, one participant mentioned to the presenting attorney that he had done exactly that, avoiding attorney fees. The attorney asked, "What did you transfer to your living trust?" The seminar participant answered blankly, "Transfer?" What he had done was to create the basket but leave it empty. Your living trust controls only the property that has been transferred to it or is listed in it. Most attorneys take care that their clients take that vital step. If you don't, your living trust may be beautifully written, but it will be virtually useless or require your heirs to plead with the probate court that you meant to transfer assets to it. It's usually not difficult to transfer your home and major accounts out of your name and into the name of your living trust. Most revocable living trusts have a Schedule A, which allows you to keep track of what's been formally transferred to the trust and to list other properties you want distributed, furniture, art, jewelry, and the like, that do not have documents of title that your house and other important assets have. I'm sure the computer software program mentioned these important steps. This is why most nonprofit organizations, including this one, encourage its supporters to seek guidance from an experienced estate planning attorney. Some people think that revocable living trusts have an additional benefit, the avoidance of estate tax. That's not true. By themselves, revocable living trusts are tax neutral. They offer no more protection from estate tax than a simple will does. We'll treat estate tax in a future presentation. For now, just remember that revocable living trusts offer no tax advantages, but they do allow you to avoid probate, and they provide some protection from court conservatorship, something most attorneys want their clients to avoid. What is a court conservatorship? Let's go back to the example where your only formal estate planning document is a will. You know by now that the executor of your will can't legally step in and take over the management of the assets mentioned in your will until you die. While you are alive, the executor is powerless to help you if you are no longer able to manage those assets. Under those circumstances, someone who wants to manage your property and pay your bills must take you into court so a judge can determine your incompetence and appoint your conservator. Perhaps the judge will appoint exactly the person you want, perhaps not. In either case, most attorneys don't want their clients exposed to a public hearing about their competence or the possibility of having the wrong person appointed as their conservator. Even if the right person is appointed by the court, he or she now has to give regular accountings to the court on their expenditures on your behalf. Like probate, court conservatorship can, in certain circumstances, be beneficial. If someone has a particularly complex estate or has no one with the competence and character to manage financial decisions for them, perhaps having a judge watching over a court-appointed conservator makes sense. If you think that would be overkill in your case, a living trust offers you an alternative for the assets governed by the trust. If you want to make sure you avoid a conservatorship, have your attorney provide you with a durable power of attorney for property management. The durable means that someone can continue to act for you even if you've lost the ability to communicate. Like a living trust, the power of attorney for property management allows someone you have chosen in advance to step in and act on your behalf under certain well-defined circumstances. The phrase power of attorney does not use the word attorney in the legal sense, a professional with a law degree. Here, attorney is used in the broad sense as someone empowered to act on your behalf. Powers of attorney are usually lengthy documents because they spell out in detail what the person you've chosen can do for you. With one in hand, the person you've appointed can step in and exercise the powers you've given to him or her for your benefit. A revocable living trust and a power of attorney for property management share two things in common. They both avoid court intervention, and they both can take effect during your lifetime. A power of attorney is a good idea even if you have a revocable living trust. The living trust covers the assets held in the trust, while the power of attorney will allow the agent to deal with non-trust assets, such as life insurance and IRAs, and make certain financial decisions such as signing tax returns. Most individuals equate estate planning with a will, which gives you control of the orderly distribution of assets at death. This is too narrow a view. With individuals living longer than ever before, the odds of needing help during your life with financial matters and property management are greater than ever. Your estate plan should address that possibility. Most estate planning attorneys will at least discuss a living trust with you, and almost all will recommend that you have a power of attorney for property management. Are there any downsides to living trusts and powers of attorney? There can be, and we'll discuss them in our next session on the crucial role of trustees. See you then.